that is to be found under Article 38 of the Constitution. But more importantly, we have a history as a country. We are a country that has been privileged to legislate on each and every issue that has been litigated before these courts. We are a country that even legislates on the time between which a president should be sworn in office, for obvious reasons, because of the history that has culminated around our electoral law jurisprudence. Now, the appreciation of the cornerstone of Article 38 then would seek refuge in the Constitution of Kenya Review Commission. This court, in the famous BBI case, categorically stated the history behind our constitutional making process. I'll not wish to regurgitate the same, but I'll beg the court, when you retire to write your judgment, to adopt your paragraphs of that decision, paragraph 415 to 441 in that respect. Again, Honorable Chief Justice and members of the Supreme Court, judges of the Supreme Court, then what culminated to the Article 38 of the Constitution? In the final review, for us to get the gist of the Kenyan voter, because all that we are trying to help this court to realize is that what was the will of the Kenyan voter as expressed in Form 34A. And the Kenyan voters said what they wanted, and that is to be found under page 51 to 52 of that report. Now, coming to my submissions on Article 38 in that respect, their views were finally codified in our Constitution under Article 38 in that respect. For purposes of emphasis and so that we do not lose the trajectory of the Kenyan voter, this is what Article 38, Clause 3 says. Every adult citizen has the right without unreasonable restrictions. That is the underlying word. The Kenyan voter wants to vote without unreasonable restrictions, to vote by secret ballot in any election or referendum. What we've been told is that there has been the restrictions of postponement of gubernatorial elections. There have been the restrictions of what happened in Bomas. A Kenyan voter is not interested in that. They want their vote to be traced and traced with the precision that is required. How then do you trace the vote in that respect? Form 34A becomes crystal clear. The petitioners have not challenged Form 34A in that respect, so that the votes that were cast and tabulated in that respect remain unchallenged. And where they have challenged, we have demonstrated before this court that it is unfounded, it is based on generalization, and it is based on conjecture. It cannot stand the test of what a Kenyan voter would want. More importantly also, Honorable Chief Justice and members of the Supreme Court, is that how then do you establish at the polling stations? Because the problem that we are having is that there are no agents who have demonstrated any problem with the voting at the polling station. Regulation 81 of the Election General Regulations provide what should happen after the voting has been conducted. That is, the valid votes to be put together, the rejected votes, unused ballots, and counterfeits. They are to be preserved for an election court. Nowhere have we been told that none of that happened, or that there was a problem with whatever happened at the polling stations. Honorable Chief Justice and judges of the Supreme Court, Justice Njoki Nugu in 2017, in her dissenting opinion, had this to say, that agents are a very important part of the electoral process. These are the agents of the different presidential candidates. Now, if they are not present to certify their role, they should then not blame any other person in that respect. We have established with our agents and filed the affidavits in that regard that indeed the Form 34As were issued to us, and it reflects what IEBC posted in the portal. The petitioners have not discharged that burden. They cannot now come back and say that they would want to challenge an election by failing to do that which they are required in law to do. What has happened? We've been told a lot of stories. We have 8 petitions, all trying to explain a lot of things. In my concluding remarks, I'll seek refuge in the Holy Book. In Proverbs 10:19, it tells us this: when words are many, sin is not absent, but he who holds his tongue is wise. They've had to use 8 petitions to say what they want to say. In those abundant words, then sin cannot be lost in that respect. It will be my humble prayer that the petitions before this honorable court be dismissed. I'll take this opportunity to welcome my learned senior, Professor Kithure Kindiki, to address you on the 6th issue. I'm most obliged.
May it please you, Chief Justice, Deputy Chief Justice, judges of the Supreme Court. My name is Kithure Kindiki for the first respondent. On 15th August 2022, a mob of people, including people holding senior positions as state officers, invaded the dais at the National Tallying Center of the presidential election at the Bomas of Kenya. In what I regard as a very, very orchestrated and clear attempt to interfere with the powers of the IEBC to declare the presidential results following the verification and tallying of those results. As a result, chaos erupted. Several IEBC commissioners, staff, and other people who were lawfully at the tallying center were seriously injured. To date, nobody has been asked even to write a statement on what happened on that day. Today, no investigations whatsoever have been made by the agencies of state which should be doing this. And to date, this heinous and frontal attack on our democracy remains unresolved, and the perpetrators are marauding around the country, and some of them are in this courtroom. Chief Justice, judges of the Supreme Court, the events on that fateful day mirror what, in our respectful view, took place on January 6, 2021, when a rowdy gang of violent protesters laid siege on Capitol building in Washington, D.C., in the United States of America, following the spectacular defeat of Donald Trump as president of that country in the 2020 election. The chronology of events of that day, the day our country was shamed in the eyes and in the presence of diplomats from all over the world, local and international press. The events are detailed in the affidavit of Mr. Wafula Chebukati, a gallant son of Kenya, that we admit that the aforesaid activities at the National Tallying Center on 15th of August 2022, regrettably perpetuated by emissaries, agents, supporters, and sympathizers of the first petitioner, who is now before this court seeking redress. Those events and those activities amount to nothing short of a flagrant attempt to overthrow the constitution of our country, to subvert the sovereign will of the people of Kenya, contrary to Article 1 of the Constitution. It is our view that those events alone constitute nothing but an attempt to establish a government unconstitutionally, contrary to Article 3.2 of the Constitution. And in our humble and respectful view, Chief Justice, my lords, my ladies, the events of that day are basically an attempted but failed coup d'etat. Unfortunately, the jurisdiction of this court under Article 140 does not allow it to punish these egregious acts of treason, but these events must inform the context in which the main petition and its offshoots ought to be adjudged. Curiously, the mentioned public officers, who include civilian state officers, including a cabinet secretary, senior military officials, including the Vice Chief of Defense Forces, Head of Police, Head of Intelligence, the Head of Public Service and Chief of Staff, which is itself is an illegal position under our Constitution. All those people have not denied that they met the IEBC in plenary. The only thing they have told this court is that they went there to try and fast-track the declaration of results and not to do what Mr. Chebukati has told this court on oath, which is they went to go and try to have the first petitioner declared as president of the Republic, or otherwise force a runoff between him and my client. With tremendous respect, we ask this court to consider those acts as not only destructive to the independence of our institutions, but more particularly an affront on Article 249, 2A of the Constitution that describes the IEBC and other such independent institutions in the following words, that they are independent, and I quote, and are not subject to direction or control of any person or authority. That includes, in our humble view, positive and negative interference, even if, for argument's sake, which is denied, that those heads of very sensitive institutions walked into a plenary of the IEBC to fast-track the declaration of result, even that in itself is illegal and unconstitutional. What are the principles upon which the context we have laid should be adjudicated? Chief Justice, members of the Supreme Court, it is the submission of the first respondent that there are at least three immutable principles that run across most Commonwealth jurisdictions upon which this petition and its offshoots should be adjudged. One is the principle that no election shall be questioned or declared void because of errors, informalities, irregularities, or illegalities that have little or no bearing to the process and the result. This principle, Chief Justice, judges of the Supreme Court, this principle has endured for more than 150 years and was first initiated in the United Kingdom Ballot Act of 1872, Section 13. 2, that the burden of proof in election petitions lies on the person who seeks judicial invalidation of the election, not on the respondents. This principle has been cited in one of the authorities we have relied in and already highlighted by learned counsel's senior counsel, Fred Ngatia, the case of John Mahama versus the Electoral Commission of the Republic of Ghana, 2021. Principle number 3, and this is specific to Kenya and the minor KI decision. The polling station is the true locus for the free exercise of the voter's will. And I'm shocked to see the petitioner and the latest pseudo-petitioner, because when I listened to the Attorney General with due respect, I clearly thought that we are listening to another petition, especially on the issue of Article 138.3c, despite the assurances that he was not opposed to any petition, and I think he fell short of saying he's supporting the petitions. What are the specific principles in the interest of time? The first one, the three are the general principles. What are the specific principles? 1, and what I intend to demonstrate with these specific principles and the general principles is that the answer to the question on the issue number 5 is in the affirmative. That yes, the IEBC carried out verification, tallying, declaration of results in compliance with 138.3c and 138.10. These are the reasons. Number 1, the verification and tallying happened and was done by the chairperson, commissioners of IEBC, and the staff at the National Tallying Center in the presence of the candidates of the agents of the presidential candidates. And this is in the affidavit of William Ruto, paragraphs in support or in opposition of the petition, paragraphs 18 to 20, and the affidavits of Veronica Nduati, paragraphs 7 to 14. Number 2, the IEBC complied because an interpretation to the effect that Article 138.3c refers to the 7 commissioners, or a majority of them, is inaccurate and pedantic for this reason, that the Constitution and the Elections Act attributes to the Commission certain acts that are eventually done not by commissioners but by both the permanent and temporary staff of the IEBC at the polling station, at the constituency the constituency tallying center and county tallying center, and I dare say even at the national tallying center. And that explains why, for example, the Constitution in Article 86.5 and 86B and 86C talks about the commission, but the work eventually is done by returning officers and in the first instance by the presiding officers. C, B, and C of Article 86 of the Constitution, which is not speaking about the National Assembly election or any other election, but the presidential election. The actions of returning officers, presiding officers, are deemed to have been done by the Commission, and that explains our argument. Number 3, an interpretation to the effect that Article 138(3)(c) refers to the 7 commissioners would lead to an absurdity in interpretation, because it is not humanly possible for the 7 men and women who are commissioners, however important they think they are, it is not humanly possible for them to tally results emanating from 46,229 polling stations across the country at the moment. Number 4, verification, tallying, and declaration was done because the right to franchise, Chief Justice, judges of the Supreme Court, this right in Article 38 of the Constitution cannot be subjected to the will, to the veto, or even to the ego of 7 men and 7 women. Even if, as they claim, they think they hold the constitutional veto to try and moderate or alter or balance the will of the people as expressed at the polling station and as received in original 39As. Number 5, verification, tallying, and declaration was done, even, I dare say, Chief Justice, judges of the Supreme Court, even for the 27 constituency results that were not verbalized. They were not announced verbally, but they were declared because they were posted in the website after chaos broke out at the National Tallying Center. I want to invite the court to consider, in interpreting whether what has been pleaded before this court in terms of what the Commission did after that risk on life and limb happened. I want to plead and persuade this court to invoke, by way of analogy, 3 doctrines of law. The first one is the doctrine of frustration in the law of contract, where there are contractual obligations to be performed, but the contract is frustrated. Number 2, the doctrine of necessity in international law. And thirdly and finally, the doctrine of supervening impossibility, where there are legal obligations, but the party on whose those obligations accrue cannot perform them as a result of supervening impossibility. Chief Justice, my lords, my ladies, number 6, the IEBC verified and tallied and declared all the results because none of the 46,229 from 34As have been impeached. Number 7, the IEBC verified, tallied, and declared all the results because the tallying that happens at the National Tallying Center is basically clerical. And I think the commissioner should know none of them, including the chairman, has any role whatsoever that is significant other than just recording the clerical and arithmetical issues. And this is so, and this explains why, even when there are discrepancies between what was transmitted through electronic means and what comes as a physical form, the best that the chairperson, as the returning officer, can do is to note the errors in the error form, and only these courts can actually interrogate and decide on the fate of those discrepancies. Number 8, verification, tallying, and declaration was done pursuant to 138.3C and 138.10 because an interpretation in the opposite direction would lead to a constitutional crisis where commissioners would think they have a role to veto and moderate the expression of the will of the people of Kenya in the vote, can decide to form factions and have their own candidates, declare their own results, which they have verified in quote and tallied in quotes. Finally, Section 10, 11, and 11A of the Elections Act envisage the commission to include the secretariats and staff, and therefore verification was done according to the affidavit of William Ruto, the affidavit of Veronica Duarte. The tallying was done in the presence of agents at the National Tallying Center. With tremendous respect, I would like to conclude by submitting that this court should find that a petitioner whose agents and supporters are engaged in a kind of behavior that is now of public notoriety, and I invite the court, over and above what is pleaded, to take judicial notice of of the events of that day. A petitioner whose supporters, sympathizers, and agents engaged in those kind of things should not be anywhere near the hallowed ground of a Supreme Court of the Republic of Kenya, trying to seek relief, among them a relief under Section 80A, that they be declared winners of an election that they didn't win. We submit that the mob that swelled our image, the image of our nation, including the conductors of the orchestra, are now before this court shouting loudest that we must release Barabbas. This court should stop Barabbas and his mob from benefiting from their own malfeasance. We pray that all the petitions, including the submissions by the Attorney General, particularly on this issue of Article 138, those petitions be struck out with costs. I respectfully and humbly submit. And now, with the permission of the Chief Justice and the court, I yield the microphone to Senior Counsel Kirago Kimani to address the court and submit on issue number 7 and number 8. I thank you.
May it please the court, I will not, my name is Kirago Kimani, I will not address you on issue number 7. I believe it's been adequately dealt with by the IEBC and its chairman. I will address you on only issue number 8, and I will try and avoid rehashing what the IEBC and its chairman addressed you, in my humble view, very effectively. This is simply looking at the test that has to be met by the petitioners in order to determine whether the election should be nullified. And you've settled this as far back as 2013 in Raila petition number 1, or it was petition number 5 actually, but it was the first election petition under the new constitutional dispensation, and repeated this in 2017. The long and short of it is that the question you must ask is whether it has been demonstrated that the election was conducted so badly that it was not substantially in accordance with the law. relating to elections, in this case the Elections Act, in Articles 81 and 86. The burden is squarely on the petitioners to demonstrate indeed this is the case. The word used by Section 83 is magnitude, of such magnitude, really. It is not enough to demonstrate there were irregularities. It is not enough to show that there was a breach of the law. But it has to go beyond that to show that it affected the outcome. Has that been done? I'm not going to take you through the multiple allegations of irregularities and breaches of the law. But I've tried to look at these petitions, the 7 surviving ones, and I think there are approximately 46 allegations of breaches of the law and irregularities. This is a classic case of throwing everything other than the kitchen sink at your opponent. There are a lot of overlaps, but by and large, everything that could be said has been said. And I'll come back to this. The kitchen sink did show up a little later. But I don't want to walk you through all of these allegations. Let's just look at a few of these. It's alleged that there has been an infiltration of the IEBC system. I'm not going to rehash what Mr. Mahatamane so well explained to you. But I think these petitions are an invitation to this court to lay down the law. It's one of your jobs. That it's not enough to show up here and throw things out there and say, we hope some of it will stick. No. People must be held to account. They must be told, show us where the evidence is. And indeed, this is what Rule 9 of the Supreme Court presidential election rules requires, that when a petitioner presents a petition, they will also furnish evidence. Has that been done in my humble submission? No. This evidence of infiltration, in the first instance, was put in various affidavits. John Mark Githongo, you've been told about how he recanted this. There were allegations in various other affidavits. And what happened then? There was a robust response from the referee, the IEBC, and the first respondent. And then what do we have? We have a second burst of alleged evidence in the nature of an affidavit by George Njoroge. And we are not even, we did want to start playing games by saying this evidence should have come at the start, as the rules require. So this case keeps being panel beaten as we move along. And it's not just petition number 5 where this happens. It has happened in another petition where you were addressed about 291 constituencies and not 290. I believe there was a question from a judge directed at this because there's a short answer to that, but the question was not directed at me. But that wasn't even pleaded. So what we have is a situation where you keep being told new things as we move along. There's another allegation that the IEBC was so dysfunctional that you couldn't possibly have an election that complies with the dictates of Article 86. And we are told that this started even before. Now the question is, why wasn't a challenge made to the mandate or to this institution before the elections? An Article 140 petition is very narrow. It concerns the results and nothing more. This petition has been turned, or these petitions, by many of the petitions, has been converted into an attack on the on the chairman or the chairperson of the IEBC. It's not the function of the court to look at the conduct of the chairperson with a view to taking action. You were addressed in great detail as to why or how he has affected the last 2-3 elections. So what were we waiting for when Article 251 tells us what to do? The Leadership and the Integrity Act tells us what to do. Let me very quickly, without going into any more of these 46 alleged irregularities and breaches of the law, just try and illustrate just how bad these petitions are, or how lacking in substance they are. And I will, Mr. Mahatsomane, my land friend, Mr. Mahatsomane, has spoken to this, but I want to illustrate by showing you just a little bit about what was contained in the affidavit of Arnold Odinga, Ochieng Odinga. And if I could just, if it could be put up, I want us to look at what has been presented before this court. And it's quite easy to come to this court and say, listen, somewhere between the people expressing their will and the declaration of the results, there has been some tampering. Let's look at what they say. Paragraphs 81 to 91 of the affidavit of Arnold Ochieng Odinga says that there was willful, deliberate, and criminal tampering of certain results, and they've identified 41 forms. What I suspect they did not expect to happen is that the IEBC would respond to just about each and every one of these forms. Let's look at just one sample. And before we do that, what are we trying to achieve? We'll look at a Form 34A from the IEBC portal. We will look at Form 34A delivered by IEBC to the court. We will look at an affidavit from a presiding officer. And we'll look at an affidavit from an Azimio agent. And we'll look at a Form 34A provided by a UDA agent. The affidavit of the IEBC presiding officer is not part of the slides, but we will be able to compare these documents. If we could skip this next slide so that we move quickly. Let's skip that slide, please. Now, the question is where the petitioner's fraudulent 34, where allegedly fraudulent 34A came from. And I'll return to that at the end. Let's just look at Kibagare polling station. The next slide, please. If you look at the signatures, one of the signatures is an ODM agent, Mr. Eric Atuma. Now, the petitioner in petition number 5 has filed many affidavits in response to the respondents, including the first respondent. They have not responded to this. They have not challenged this. But they put it out there as an illustration of what games were played, either by the referee or in concert with the first respondent. So the first thing you note is the signatures of the two agents. The next thing I'd invite you to look at is what the votes were according to the IEBC portal. And Malan from Mahatsomane invited you. The portal is up and running. Check this. What was the total of votes cast, or what was the, for the two candidates in Kibagare polling station, stream 2 of 7? Raila Amolo Odinga, 244. Mr. William Samoei Ruto, 114. Let's go to the next slide. If you look at the affidavit of the presiding officer, he's produced a similar Form 34A. It says it gives the same outcome. The next slide. The UDA agent, same 244 and 114. Then you have the next slide, the Azimio agent, again, 224, 114. The next slide is the affidavit of their own agent. He says, what is in Mr. Odinga's affidavit is not what I submitted to the party. They decide, we're not going to respond to that. But we expect the court somehow to determine that there were fraudulent Form 34As. Is this right? Let's go to the next slide. What is in Mr. Odinga's affidavit? Look at the last column. It says, for Raila Amolo Odinga, 244 votes. For Mr. William Samoei Ruto, 38. What happened to the other votes? Something is fundamentally wrong. And this is just one document. We have filed other affidavits which illustrate what happened here. Let's look at the next slide. The law requires the IEBC to deliver certain forms. I'd invite the court to look at the form for this particular location, this particular polling station, and see whether what has been set out in Mr. Odinga's affidavit is correct. Let's go to the last slide. What then are we telling you? The numbers between the IEBC portal, the IEBC presiding officer, the UDA agent, the Azimio agent, and the Form 34A from Bomas are all aligned. Question we must ask is, where did the form that is presented by Mr. Odinga come from? Arnold Odinga, so that we do not mix up names. I think this must be what the late Issa Juma of Super Wanyika had in mind when he penned the words, sisi twajua anafanya biashara, lakini biashara anajua mwenyewe. Only Mr. Odinga can tell us where this came from. And the other 40, they are not part of what was actually the product of the people expressing their will. So, in a nutshell, even without trying to demonstrate to you how the other irregularities and alleged infringements of the law have not affected the law, the petitioners fall far short of what is expected. But let me look at one or two things, because one of the things that has really featured a lot, and I'm going to try and avoid rehashing what has been said by the other lawyers, is that the commissioners have a significant role. That what 138(3)(c) means is that the commissioners, the 7 men and women, have to be involved in the exercise that is to be undertaken. With respect, this submission is skewed by a failure to interpret the Constitution correctly. I think it's long been settled that the Constitution, the interpretation of the Constitution, looks both at the text and the context. And what has happened here is that the petitioners have decided we will stick with the text. And even that they stretch. They say the IEBC, the commission, means there's 7 of them. With respect, that's an invitation to the Supreme Court to, through the back door, overturn what Maina Kiai said, which is that you start at the lowest level and cascade things, but it is not the job of 7 men and women. Let's look at the 7 commissioners a little more. and in particular the 4 who it is said should lead to the conclusion that the election was not conducted in accordance with the Constitution. They were on board with every other commissioner. They spoke with one voice until about 3 p.m. on the 15th of August. Then they had their Damascus moment and made it to Serena. They changed their position. If you look at the affidavit of Samuel Gidai, look at the clips of the 4 commissioners announcing the results. But you were told here yesterday they were being given pieces of paper to read out numbers. Is this believable? But we were told by another speaker, another advocate, that these men and women were vetted by the National Assembly. They are therefore very serious citizens who correctly undertake a very important function, the running of elections. But they say they did not participate in this. In determining who to believe, look at the context. Look at the whole series of events from when the nomination took place, when the ballot papers were printed, including the supervision that they undertook, and determine whether these 4 commissioners are to be believed. Mr. Njenga, for I think the 7th respondent, argues they are here not to support either side, but to discharge their duty under the Constitution. But they did file a response. They started off by filing affidavits to set out the evidence. There's no property in a witness. They didn't stop there. On the 26th of August, they decided we will appoint another lawyer on behalf of the IEBC who is in effect going to admit the alleged infringements. This is where you apply the duck test. If it looks like a duck, if it swims like a duck, if it quacks like a duck, it must be a duck. They are saying we are here to show you we are independent. Are they? With respect, their conduct demonstrates otherwise. In a word, it is my humble submission that the petitioners have not demonstrated there were any irregularities or illegalities. Forget the magnitude. They really haven't demonstrated any. I'd urge you to dismiss these petitions. Ordinarily in these sort of cases, and I'm not telling you what to do one way or the other, because of the nature of the matters, the parties are asked to bear their own costs. But again, what happens in 5 years if people can come in 8 petitions, 1 was struck out, and say whatever they wish to say without offering evidence? I think there was some advocate who said yesterday, we're going to have 200 petitions in 5 years. Why? Because there are no consequences. We can all come here and be on television. There are no consequences. So what are we asking of you? We are asking you to give us back our country. Determine that there were no infringements, that we had a proper election. We have been in election mode for so long. The only thing that creates wealth is actually working. And this is not work. With respect, the tens of thousands, men and women who preside over elections are teachers and farmers and artisans and you name it. We're being asked to make them come back to work in a few months, or in 60 days to be precise. There is no justification for that. The order that should commend itself to you is to dismiss these petitions because they fall far short of what is required. Those are my submissions. Mr. Kioko Kilukumi will now address you on the 9th issue.
Your Ladyship, the Chief Justice, Deputy Chief Justice, Justices of the Supreme Court, my name is Kioko Kilukumi, and I appear for the first respondent. Our team leader has asked me to deal with the issue raised by Mr. George Oraro, Senior Counsel, in regard to the affidavits filed by Joseph Kinyua and Kennedy Kiara. This court did direct that the first respondent is at liberty to come and place the facts he has before this court, not through affidavits, but we've been given the permission to place the facts because time was running and the court directed we have that time. The first respondent wishes to place it on record that under Article 240 of the Kenya Constitution, there is established a National Security Council. And he is, by virtue of being the substantive deputy president, is entitled to sit in that council. He says, in the last 5 years, the council has not sat and discussed anything to do with elections. He further says that matters of election are vested in an independent body, and that independent body is the IEBC. That is the body that has the constitutional mandate to deal with elections. He further says, during that period of 5 years, the Council has not asked the National Security Advisory Committee to deal with IEBC on any matter relating to elections. And he takes the position that the visit by members of the National Security Advisory Committee to IEBC at the Tallying Center was an interference with the functions of IEBC. And it was calculated, given the membership who was sent there, it was designed and calculated to intimidate the chair of the IEBC and to seek to influence the outcome of the election. We ask the court to note that these affidavits were provoked by what Mr. Chebukati said in his affidavit sworn on the 26th of August, 2022. From paragraphs 55 to paragraph 75, he has given a subheading and he calls it an attempt to subvert the will of the people. And we invite the court to consider those paragraphs and to see which party is telling you the truth. We wish to refer you specifically to paragraph 66 in that affidavit. And it is an important averment, an important deposition in that affidavit. He says, Mr. Chebukati, when he was at the National Tallying Center, members of the National Security Advisory Committee visited him, and he sat with them after 2 p.m. It is important to contextualize the time. We are talking of the 15th of August. Bomas of Kenya, there is a meeting, and this meeting is attended by all the commissioners. All the 7 commissioners are there. The fact of that meeting is not disputed, or the affidavits filed regarding that matter make critical admissions The first admission is that indeed Joseph Kinyua telephoned Chebukati and told him, I'm sending my members to you. That's an admission. The second admission is that all the commissioners, and these are the affidavits from Mr. Joseph Kinyua and Mr. Kenneth Kiara, all the commissioners were present. It is past 2 p.m. It doesn't say how long this meeting took. The country had been put on notice. Elections results will be declared at 3 p.m. And once you look at the paragraph I've referred the court to, Mr. Chebukati says the message from this powerful committee was simple. Declare these elections in favor of the petitioner, the first petitioner, in petition number 5. If you are not able to do so, please massage the electoral data and force a runoff. And now that issue was discussed openly by the members of this powerful committee and all the commissioners in IEBC. The 4 commissioners made it very clear the suggestion from the Security Committee is reasonable and we should actually accommodate it. We should think of doing it. The 3 commissioners, and all of them have sworn affidavit attesting to that. The 3 commissioners said, nothing doing. We will declare these elections in accordance with the Constitution of Kenya, and we will declare the legitimate results. And so we ask the court, you do not have the advantage of witnesses being cross-examined, but you have the ability to look at all the accounts and see which account is more probable. The meeting starts past 2. Elections were to be declared at 3. At 4 p.m., the 4 commissioners are in the Serena Hotel. Our TV screens has been split. One side says 4 commissioners are disowning the results. The other screen is showing us chaos in Bomas, attack on the chair of IEBC, attack on the 2 other commissioners. Do you believe, will this court believe, that members of the National Security Advisory Committee was going to discuss matters of security? In less than 1 hour, 2 hours, the electoral commissioners are being assaulted, and this is being broadcast live. Assaulted, a cognizable offense. Police are in Bomas of Kenya. Nobody's arrested, and the people who are doing these attacks are well known. So we ask you to consider that fact in trying to see which account is likely to be true. The commissioners at Serena Hotel opened by saying, we've conducted a very good election. It's only gone bad towards the end. You will ask yourselves, does somebody disown results which he doesn't know? Do you believe these commissioners did not know what the outcome has been? We submit they knew the result, and that is why they were disowning it.
is the most photographed house in Africa.
We have 5 rooms. There's a family room that can take 4 people. We have the Lamu room, Moroccan room, and the Bakuba room. Those are teams. That's simply because most of the artifacts that you'll find within those rooms are from the regions that I've mentioned. People come here for just to go through the tour and learn about our heritage and see these things that most of them you can't find anywhere right now.
To watch this story and more, download the Citizen Digital app today.
Kenya's #1 app, Citizen Digital.
Cascade Institute of Hospitality nĩ njorua harĩ ũthomithia wa kothi cia hospitality na tourism na nĩ kũndũ kwega gwa gũthomera na kwĩna arutani qualified. Cukuru ũyũ nĩ ũhetũkĩtio nĩ rũhonge rwa kĩmabũrũri nĩruo Confederation of Tourism and Hospitality CTH rũrĩa rũheanaga diploma na certificate courses itambũrĩkanĩte thĩinĩ wa thĩ ta hospitality management, culinary arts, pastry and baking na tourism. Arutwo a Cascade Institute of Hospitality nĩ makoretwo makĩandĩkwo mawĩra nĩ Celebrity Cruise Ships ta the Royal Caribbean na MSC. Thimo nĩ 0703 777 888. Rĩrĩa wanyita bonathi yaku kana kĩgĩna gĩaku kĩa ritaya nĩ wega kwĩyũria nĩ biacara ĩrĩkũ ĩngĩ ũngĩhũra nĩgetha ũthiĩ na mbere kwĩyonera kĩndũ o mweri. Shera Maridadi Motors ũthomithio ũrĩa ũngĩingĩra biacara ya ũgũri na wendia wa ngari kana ũkombani wa ngari nĩyo lease selling ũkeyonagĩra faida o mũico wa mweri. Maridadi Motors tũkoretwo biacara-inĩ ĩno gwa kahinda kakĩrĩte mĩaka 10. Ningĩ no tũgũteithie kũ import ngari yaku kĩũmbe na thogora mũbacĩrĩre. Waigithia na ithuĩ kana wagũra ngari nĩ tũrakũhe smartphone. Thimo nĩ 0798 00001.
Nice and Lovely imetunza ngozi yetu for over 25 years. Sasa inatujali with the best of her jelly na the best of her cream. Sawa.
Gundua jelly in cream ya kwanza duniani kutoka Nice and Lovely. Nyepesi kama cream na inalinda kama jelly. Nice and Lovely jelly in cream leaves no grease.
Jaribu the best of her na the best of her creams.
And you get the majority of votes, you become the president. 7 commissioners cannot make you the president. 4 commissioners cannot make you the president. Who makes the decision as to who becomes the president of the Republic of Kenya? It is our humble submission. It is not the commission. It is not any of the commissioners. It is the electorate. It is the people of Kenya. And therefore, this narrative that we are the majority, we needed to sit down and make a decision, that decision as to who becomes the president of Kenya does not lie with the commission. Theirs is to midwife the process, and that is all they can do. We wish to submit that the first respondent won these elections fair and square. You've had the submissions and the evidence that has been presented by the midwife, IEBC. And they have made it absolutely clear that this election was conducted in accordance with the Constitution. It was computed in accordance with the Constitution. And they have a very clear winner as to who obtained the highest number of votes and made all the requirements required by Article 138(4). For that reason, we ask this court to consider that this petition is the consolidated petition are founded, they are all anchored on fiction. They are all anchored in forgeries. They are anchored in fraud. That clearly tells you this petition. I wish to ask the court amply to reflect on the ruling of King Solomon. Just like King Solomon before you, you have 2 gentlemen here, each one claiming a baby. The baby they are claiming is the outcome of the 2022 days of Solomon. They easily make up a decision as to whose baby is this. Today, as competing for this baby, you have two gentlemen, each one of them claiming the baby. What does the petitioner ask you to do? Just like the days of Solomon is telling you, give me the baby is mine. And then he goes on to tell you, if you cannot give me the baby, slice it into two. We can call this baby Victoria. We can call this baby Victor. But the more gender-neutral term, we call this baby Victory. Baby Victory is a clean DNA. His DNA is captured in the original Forms 34A. DNA is captured in Forms 34B. In Forms 34B, that baby belongs to Honorable William Samoei Ruto. Give him his baby. Don't divide the baby. The petitioner here is telling you, you either give me the baby or cut the baby into two. Nullify the election. Solomon used that indicia to know who was the true mother of this child, because no mother would want a baby chopped into two. And so by the petitioner coming to tell you here, if you don't give me the baby, slice the baby into two, you already know whose baby the victory of 2022 presidential election is. I urge the court to give the baby to the legitimate and lawful father, who is Honorable William Samoei Ruto. Thank you very much. I'm sorry, Your Ladyship, the Chief Justice, Justices of the Supreme Court, I wanted to yield the floor to my senior friend, Gatia, Senior Counsel. Thank you.
Madam Chief Justice, my duty is to make closing submissions as I also deal with the last issue. What are the appropriate reliefs? Yes. Oh. I start by apologizing. I left out two members of my team, two lawyers who have worked very hard, Rose Thiongo and Ham Langat, Mr. Ham Langat. I think in fairness, it's good I place them on record. They have done a sterling performance, and this is part of the mentorship we should do. Madam Chief Justice, let me also start by apologizing that I did not place on record the fact that we did file written submissions on 27th August this year, and we rely on those written submissions. We took lots of time to actually develop almost a treatise on the origin of Election Act. We went to 1870 in England, where we found the first codification of the Election Act, and the subsequent development and the hesitation by apex courts in not disturbing electoral victory. I would request you, in the fullness of time, please look at it. I should also, in fairness, indicate that the authority I referred to from Ghana decided last year the Mahana decision is authority number 5 in our list of authorities. And again, this, Madam Chief Justice, let me say this because I ought to acknowledge it. Judges in Ghana quoted with approval one of your judges. writing of this apex court are now being quoted with approval in the continent of Africa. And if I could say so, this is also because of the very vibrant advocacy by my learned friends. So if we could participate in enriching the jurisprudence in Kenya and Africa, so be it. I now go to a very brief response overview. You have a petition before you by Julia, I think is now number 7, the one about special group of people, 500,000, who allegedly were denied the right to vote. And this is what we call not now fiction, but theory, pleading or drafting a petition on the basis of abstract principles. The so-called 500 people, not a single one of them have filed an affidavit to say because they were working for IEBC or were working in any hospital, they were deprived an opportunity to vote. In other words, this court must also try to establish some rules of engagement. Are we going to be holding this country at ransom as we process these petitions, which are, to say in very modest terms, very frivolous? One comes and says 500 people are denied an opportunity to vote, and then he gets away with it. Juria is a very good example of what states in America have now resolved to do. They do punish a pleader who files a pleading with the full knowledge that what is being pleaded is incorrect. I go to another area of so-called suppression of votes. This is another constant denominator, that the suppression of vote because one level of votes was not held. And the question is, where is the empirical evidence that because there is no voting for a senator, then the turnout for votes for the presidency are suppressed, and suppressed in relation to only one candidate, not both candidates. My learned friends have talked about what yesterday was being called dysfunctional IEBC. It is not dysfunctional IEBC. It was a functional IEBC until 3 p.m. on 15th. On 15th August, towards 3 p.m., some commissioners were hijacked with their free will, and they opted to walk out from their brothers and sisters. There is a point that concerns me as a regular practitioner in this court, in these electoral cycles. And this is this. For how long are we going to allow our political class to advance self-interest, and to hold this country in perpetuity of uncertainty? That is something I think, Madam CJ, you now have an opportunity under Section 3 of your Act. The first fundamental in Section 3 is your true north, is supremacy of the Constitution. Your true north being the supremacy of the Constitution, and then other factor to consider is that this court is required to help us develop even a political path for this country. Those two becomes very important aids in how we deal with the political class. I'll come to that towards the end. But it is something of concern because unless it is captured early, I do not see great hope in the way we are proceeding. Madam CJ, first and second respondents are very ordinary Kenyans, very ordinary, humble origin, and this is a country I always have thought is a country of hope and opportunity. Hope and opportunity for each and every Kenyan. A child from humble origin ought to aspire one day to be a Chief Justice of this country. A child of very humble origin ought to aspire to be a top surgeon in this country. I say all this because, in all fairness, unless we show hope and opportunity to all, then we'll be missing an important aspect of our growth. There were questions that were posed to my learned friends. Since I won't have another opportunity, allow me just a few minutes to deal with a few of them. I'll start with the first question about rejected votes. It was posed by one of the judges. Rejected votes is a point we litigated in Raila 1, that's 2013, not as a side issue, but it was the subject of a petition. In 2013, there was a petition dealing with nothing but rejected votes. Rejected votes, Madam CJ, can be the third candidate. It's very easy for rejected votes to be the third candidate. And in 2013 at Bomas, where I had the pleasure and privilege of being the chief agent for the candidate, it became quite obvious that rejected candidates will be the third candidate in that contest. And if they were to be factored, then the whole purpose of rejected votes is to bring down the victory of the candidate who would otherwise have won. So it is a point we litigated at length. Some of my learned friends, my seniors, we litigated at length, and this court held and found that what is to be considered are the valid votes cast. So in my submission, that is a point that has been dealt with. It was again repeated by the court in Ghana. Last year, they rejected the notion of considering rejected votes in the final tally. As a matter of fact, now that I remember, I'm getting a little older, I was clearer then in 2013, it is a misconception to call them rejected votes. It is actually rejected ballot, because a vote is that which is valid, which expresses a choice. So those so-called rejected votes are actually rejected ballot papers. The same holds true for spoiled ballots, and the same holds true for stray ballots. As fate would have it, you will not even know about the stray ballots at the point that the tallying is going on. I associate myself with the submissions made by my learned friends, IEBC. They are the ones who conducted the election. It is not within our place to supplement their submissions. We wish to associate ourselves with the submissions, particularly as regards how the election was conducted. I come to what is the elephant in the room, to quote Tata, who I have never quoted before. What is the way forward? On the one hand, you are being requested by many of my learned friends, actually all of them in unison, is the first time I have seen, So many lawyers making the same request. Nullification of the election. Almost reminds me of the trial of Christ. Crucify him. Nullify the election. After nullification of the election, no solution is provided. But all they request is nullify the election. As you consider the rival position, I will request you to consider the following. In the event you nullify the election, you will effectively be rejecting the substantive truth that the majority of voters in this country express their free choice. While considering that plea of nullify the election, we shall be acceding to a very dangerous trend in this country, that presidential elections are to be held, and if I'm aggrieved, not because of any error, but I want to hold the country at ransom, I will walk to the Supreme Court and the election will be nullified. While considering that request, please also consider the far-reaching consequences that we all participated, we all experienced in 2017. That is on the one hand. On the other hand, the first and second respondent come to you with a request. The request is, voters did exercise their right. Hold them to that covenant. The covenant is they made a choice. Do allow the country to now move forward. We cannot and cannot afford election mode in perpetuity. I think I have said enough to demonstrate where my mind is. It is time for finality and stability. Finality and stability. In doing so, Madam Chief Justice, you'll be sending yet another signal to the political class. And here I am not finger-pointing anybody. As I said in 2013, what I say for this client is what I'll say for the next client who is in that class. The country does not belong to them. This country belongs to all of us. And since the country belongs to all of us, no person should consider that there is an entitlement. Considering that there is an entitlement is to engage in an illusion. That illusion ought to be replaced by reality. Reality is that it is voters who make their choice. And once voters have made their choice, let us inculcate a culture that my brothers and sisters on this side are now used to. We walk to our court, we may think the law is on our side, we may think we are entitled to victory, but we accept the verdict of the court, because much as we may think we are eloquent litigators, the final word is always with the court. With those comments, may I very humbly and respectfully request this court to let this cycle come to an end so that we can get back to our business, the business of developing our country. With those remarks, I would wish to close and to donate the 30 minutes to the court because we are patriotic enough to know that it's not really in the interest of this country to engage this never-ending circle of litigation. Thank you very much. Unless you have any questions for us, that's the end of our case.
Thank you very much. We appreciate the donation and the appreciation that this time that we have is very, very tight, because for us, the work actually begins when we finish all this. The bench will have questions to those submissions that have been named today. But I think there are a few who might also want to add some questions to the petitioners, especially the commissioners who are supporting the petition. I think what we want to do now is take a short health break, resume at 5:20, and this is going to be the order of business. We will ask questions to the petitioners and the commissioners who are supporting the petition. They will still respond tomorrow when they are doing their responses. But for the respondents, the first and the other respondents, we will request them to answer today the questions. We will also share the report on the scrutiny and the orders that were issued by this court on the discovery issues, the application by the petitioners. I think it was the first petitioner, Kerif Karifa, and the youth advocacy. They had applications for scrutiny. That report is being finalized. It will be shared. And tomorrow we will give you an opportunity to respond to the report. So we will adjourn for just 20 minutes.
Emergency bana.
Ero.
Wazee wamekata kuchukua dowry. We need more cows.
Kata nita video call.
Wewe jana unataka kutuanisha kitu gani?
Sasa nataka Billy the Goat, Cowboy ama Cowgirl.
Mkono paka network. Huko.
My friend, unaishi msitu gani?
Airtel 4G my friend. Ni kama oxygen. Iko kila mahali. Hiyo ng'ombe na mtoto yake patia mimi 70,000. How na kusort aje?
Na cowdy shells.
Nitumie na Airtel Money na iko free. Nimerisi. Kata simu. Nataka ku live stream the game.
Experience our expanded 4G network coverage and send money for free on Airtel to Airtel. Make Chaguo smarter on voice, data, and now on Airtel Money. Airtel, the most affordable network.
Oh yes!
yes, ithuĩ Top Care nĩtũrakwĩra asanti sana nĩgũtwarana na ithuĩ thabarĩ ineno ya oigithia na rĩu no tũrakũririkania atĩ twĩna mũgũnda Juja na nĩguo Juja Paradise Phase 31 ũrĩa tũrendia 695,000 na kuo Joska twĩna Shujaa Gardens ũrĩa tũrendia 595,000 only na mĩgũnda ĩno yerĩ warĩha ngiri igana rĩmwe ũgetĩkĩrio gwaka hau icio ingĩ tũkarĩkanĩra naguo mũgũnda wa Matu tũrendia 195,000 mĩgũnda ĩno yothe nĩ mĩirige wega ĩna gate maĩ na thitima.
Ofici citũ ciĩ Rũai Town kana Rũirũ tũhũrĩre thimũ namba 0708 000 999. Top Care nĩ mũciĩ waku mwehokeku wa ũhigithia.
Nice and Lovely imetunza ngozi yetu for over 25 years. Sasa inatujali with the best of her jelly na the best of her cream. Sawa.
Gundua jelly in cream ya kwanza duniani kutoka Nice and Lovely. Nyepesi kama cream na inalinda kama jelly. Nice and Lovely jelly in cream leaves no grease.
Jaribu the best of her jelly na the best of her cream.
Ũndũ ũrĩa makagia aciari makĩria nĩ mũtũrĩre wa ciana ciao thutha wa kũrĩkia college. Ũndũ wa kĩeha nĩ atĩ aingĩ ao macokaga kũrĩ aciari nĩ ũndũ wa mahũthĩro kana magatũra methaga mawĩra. Gũkũ Meru Institute of Business Studies tũheanaga kĩhonia. Gũkũ arutwo nĩ maharagĩrĩrio gwĩthũkũmĩra marĩ o college na makerũgamĩrĩra thutha wa kũgraduate. Intake ya September no irathiĩ na mbere harĩ kothi ciothe cia NEC cia business na technical campus-inĩ citũ ciothe. Meru Institute of Business Studies, turning skills and talents into wealth through problem solving. Hihi no wende kwĩgĩra handũ hega ha gwaka nyũmba yaku ya gũikara kũndũ kũhoreru na gũkũrĩte. Kambuni ya West Hill Shelters Limited nĩ makũreheire Hillside Gardens Mũthara o haha wĩteithie ndagĩka 15 kuma Thika Super Highway. Kwĩna maĩ, thitima, mathukuru na ngari cia ũkui wa mũingĩ. Wĩgwatĩre broti na thogora mũbacĩrĩre wa ciringi 499 handũ ha 550 wagũra cash. Tũcerere Ruiru Town Gĩtuamba Plaza 3rd floor office number L20 kana Thika Town T Plaza 4th floor. Nitutwaraga andũ mũthenya kuona broti hatarĩ marĩhi. Ũhoro makĩria hũra thimũ 0727 200 100. West Hill Shelters Limited. Invest today for your better tomorrow.
Since the pandemic, all mums know to be cautious of the many kinds of everyday germs that spread easily. Get peace of mind and protect the ones you love with the power of Dettol bar soap. It cleans and protects from up to 100 illness-causing germs. So no matter what type of mum you are, trust Dettol.
Oh yes, ithuĩ Top Care nĩtũrakwĩra asanti sana nĩgũtwarana na ithuĩ thabarĩ ineno ya oigithia na rĩu no tũrakũririkania atĩ twĩna mũgũnda Juja na nĩguo Juja Paradise Phase 31 ũrĩa tũrendia 695,000 na kuo Joska twĩna Shujaa Gardens ũrĩa tũrendia 595,000 only na mĩgũnda ĩno yerĩ warĩha ngiri igana rĩmwe ũgetĩkĩrio gwaka hau icio ingĩ tũkarĩkanĩra. Naguo mũgũnda wa Matu tũrendia 195,000 mĩgũnda ĩno yothe nĩ mĩirige wega ina gate maĩ na thitima.
Ofici citũ ciĩ Rũai Town kana Rũirũ tũhũrĩre thimũ namba 0708 000 999. Top Care nĩ mũciĩ waku mwehokeku wa ũhigithia.
Chakutumaini sina ila damu yake Yesu, sina wema wa kutosha dhambi zangu kuziosha.
Hamjambo wa Kenya, naitwa Eston Ita. Ukitaka kupata wimbo huu ambao ni cha kutumaini sina, uwe kama sikiza tuni yako. Bonyeza *811*402#. Kumbuka, sikiza na Citizen ni nyumbani kwa wasanii wote. Asanteni.
Shesheni ya Inoro TV.
thino kaririku ona mukeranagia na njoni agathi gwetha gacoko tuku na wamurora mandari onaki ati hakiri atahuthagira na nĩ kũrĩ ũkomaga kaigania amenoga iguaga na ageni na ndũkaigua atĩ nĩararagĩra mĩthemba ya Ngai ĩtũtũragia indo ciothe nĩwe waciũmbire iria ciothe ithuĩ twĩriragĩria nĩciekena nĩwe heanaga ti kĩo kĩandũ kana kũhĩga imahete indo muoyo na mbia kawega kanini nĩ kaiganu gũceranagĩre na thamaki tuthiũrũrũkĩirio nĩ mĩtino nĩtha cia Ngai tũgitagĩra ona indo ciaku no cikũnine Ngai mwene ũcihoreragia ũcio mũrata mũranyitana na gwĩkĩke ũndũ riganĩre nĩ kũrĩ wĩiguaga mũrata agacoka nyũmba keingĩra nĩ beba ya Ngai tũtũragia indo ciothe nĩwe waciũmbire iria ciothe ithuĩ twĩriragĩria gĩciekena nĩwe heanaga ti kĩo kĩa andũ kana kũhĩga imahete indo muoyo na mbia kawega kanini nĩ kaiganu ũceranagĩre na thamaki ndũkana twĩre mũndũ mahĩtia angĩkorwo ndũmuoyagĩra ũngĩigua eka ũndũ arekire ũtanaborota wĩyorote ithuothe gũtirĩ ũtarĩ itemi mũtũrĩre-inĩ wa mũndũ ũrĩa ũngĩ no mũcenje kana ũmumanie kiugo gĩa kanua tu nĩ kĩiganu nĩ beba ya Ngai tũtũragia indo ciothe nĩwe waciũmbire iria ciothe ithuĩ twĩriragĩria gĩciekena nĩwe heanaga ti kĩo kĩa andũ kana kũhĩga imahete indo muoyo na mbia kawega kanini nĩ kaiganu ũceranagĩre na thamaki kuma gũciarwo nginya kũigana arata nĩ aingĩ mũno ndanagĩa angĩ ndionaga ta tũkoranwo ona gatarĩ makanguna kũrĩ nao ndathire na ngoro ũmũthĩ nĩo manyitĩrĩire ningĩ marora maitho nĩ thoni gũtirĩ mũndũ ũtangĩkũguna nĩ beba ya Ngai tũtũragia indo ciothe nĩwe waciũmbire iria ciothe ithuĩ twĩriragĩria gĩciekena nĩwe heanaga ti kĩo kĩa andũ kana kũhĩga imahete indo muoyo na mbia kawega kanini nĩ kaiganu ũceranagĩre na thamaki mũciari ndũkamene mwanake wamwona hakuhĩ na mwarĩguo kana wamwona ũkaima na ithanwa kaba wa ihindo matarage kaba ũciaro nano kamũmenya na nĩũĩ kũrĩa ũngĩmũruta kũrĩa ngĩmonanaga na thiri macũngĩrĩro kanjia kwĩrira nĩ beba ya Ngai tũtũragia indo ciothe nĩwe waciũmbire iria ciothe ithuĩ twĩriragĩria gĩciekena nĩwe heanaga ti kĩo kĩa andũ kana kũhĩga imahete indo muoyo na mbia kawega kanini nĩ kaiganu ũceranagĩre na thamaki ndũkareke mũndũ tawe arĩre maithori nĩ ũrogio tarĩ mbũgũ marehagwo nĩ ruo rwa ngoro mũndũ tangĩhota kwĩyũrĩria tondũ ũcio gũtigagĩra Ngai nĩkĩo rĩonaga ta warumirwo ndũrĩ ũndũ ũngĩambĩrĩrio thereme nĩ namwe wathira ũngĩ ũkaingĩra nĩ beba ya Ngai tũtũragia indo ciothe nĩwe waciũmbire iria ciothe ithuĩ twĩriragĩria gĩciekena nĩwe heanaga ti kĩo kĩa andũ kana kũhĩga imahete indo muoyo na mbia kawega kanini nĩ kaiganu ũceranagĩre na thamaki nĩ beba ya Ngai tũtũragia indo ciothe nĩwe waciũmbire iria ciothe ithuĩ twĩriragĩria gĩciekena nĩwe heanaga ti kĩo kĩa andũ kana kũhĩga imahete indo muoyo na mbia kawega kanini nĩ kaiganu ũceranagĩre na thamaki karũgendo karĩa mũtwaranĩte na Ngai ũtanagacĩra ndũkanariganĩrwo karũgendo karĩa mũtwaranĩte na Ngai ũtanagacĩra ndũkanariganĩrwo ti karũgendo kaũthĩ gĩgakinya hau ndũkanariganĩrwo ti karũgendo kahũthũ mumanĩtie kũraihu gĩgakinya hau ndũkanariganĩrwo ũmenetwo nĩ andũ nĩ kuonwo tarĩ kĩene nginya maruga mao matingĩagwĩtĩire tondũ na kanyamũ gakũruta wendo arĩ ona gakuo kega gakwĩruta karũgendo karĩa mũtwaranĩte na Ngai ũkanagacĩra ndũkanariganĩrwo karũgendo karĩa mũtwaranĩte na Ngai ũkanagacĩra ndũkanariganĩrwo karũgendo kahũthũ mumanĩtie kũraihu gĩgakinya hau ndũkanariganĩrwo karũgendo kahũthũ mumanĩtie kũraihu gĩgakinya hau ndũkanariganĩrwo ririkana ũrĩa wararagũkĩrĩra ũgĩthaitha Ngai nĩguo akũririkane ũmwĩraga rĩrĩa agakũririkana ndũgatiga kũganaga mawĩko karũgendo karĩa mũtwaranĩte na Ngai ũkanagacĩra ndũkanariganĩrwo karũgendo karĩa mũtwaranĩte na Ngai ũkanagacĩra ndũkanariganĩrwo.
Thank you very much. I will invite the Honorable Justice Ouko to begin with these questions.
Thank you, Judge President. I have a couple of questions. I'll start with Mr. Mahat, who, without leave, proceeded to convert this courtroom into a classroom. Mr. Mahat, there was an allegation that 33,000 vote differential were noted between the votes cast for the president and those for governor, senator, women rep. You tried this morning to explain that some of those instances arose from stray ballots. Would you tell us how many constitute stray ballots? And can you also share with us how those stray ballots are distributed in terms of counties? Related to that, did you have, in your analysis, did you have any instances where voters walked into the polling station, voted for the president, and no other candidate or no other category of candidates? What in this court we call the Mwilu question, in reference to my lady, the vice president, I think arising from the 2017 question that I think my lady and my lord, Mr. Justice Smokin Wanjala posed. Did you have any of those where you are issued with 5, 6 ballot papers, but you don't utilize all of them? Senior Counsel Kamau Karori, the appointment of the chairperson of the IEBC was gazetted by the chairman himself. I would like to know whether he was gazetted as an agent of the commission or he was gazetted as as National Returning Officer in his capacity as the chairman of the commission, and whether, if it was as an agent of the commission, whether there were any resolutions preceding this appointment. I'm back to Mr. Mahat with the question of voter turnout. According to your presentation on PowerPoint this afternoon, you said there were 45,994 voters who were identified through Kim's kit, and this is out of 46,229. Sorry, that Kim's kit were used in 45,994 polling stations out of 46,229. That gives us 235 polling stations, which I assume I did not use Kim's kit. Therefore, assuming that the manual system was employed to identify them, are you able to say the numbers from these 235 polling stations? I saw some figures like 860 or 86,000, 114,000. So if you can just clarify that for us. And again to Mr. Mahat, because he dealt with figures. Mr. Umtata yesterday presented also a PowerPoint to demonstrate that 1.6 million votes were cast or were streaming in many hours after the closure of voting. If you can also respond to that question. Mr. Gumbo, both Mr. Issa and Mr. George Oraro, Senior Counsel, in their submissions talked about how Kenyans were following the streaming of results live. And then something happened and that stopped. Can you explain to us what may have happened for this to have stopped? My lady, those are all I have. Thank you.
Thank you, President, and thank you, Council. Again, your submissions were most helpful. We thank you. Professor Muigai, you said that the whole dispute revolves around numbers. And you were before us in 2017, and the question of Section 83 of the Elections Act was prominent at the time. Morgan versus Simpson was prominent. You were Attorney General at the time. A number of things happened around Section 83 post our judgment. My question is, looking at the quantitative test, and Professor Kindiki raised the question too around Section 83. I had it before he raised it. Could you speak to it? And what is the approach you should take in this case regarding the test to apply? Number two, again to your team, and any of you could answer it. It's not a flippant question. I'm raising it deliberately because I have reason to. I know that the events of 15th August are in our minds, but remember that there was an extra day by which Mr. Chebukati could have declared the result. Why did he not wait until that day? Violence or no violence? Perhaps you have another reason. Reach out to the commissioners, the four that are now named the four. Try and reach a consensus. Address the question of the 27 constituencies so that these suspicions that have now cropped up would not have been an issue. Is there any other reason why he did not take advantage of the extra day to do what he had to do? Mr. Oraro, I understand where you're coming from. I understand where your clients are coming from. I understand where Mr. Kenyo and Mr. Kihara and the rest are coming from. We are now in a spot where Public office is becoming exceedingly dangerous. Falsehoods are being peddled, not just to those on this side, but more even on this side and those outside. So I understand the need for you to say, my clients would like to clear their names because they've been mentioned in these proceedings. But let us come back to the proceedings, the pain of social media, the pain of affidavits aside. What do you want this court to do with the information you've given us? So we have had your side of the story. We've had Mr. Chebukati's side. We've had Cherera's side and our colleagues. What do you tell the court to do in the context of this judgment, in the context of the issues for determination? What do we do with the matters you placed before us? And while you're at it, you also mentioned Section 83. Say something about Regulation 87.3. Perhaps since you appear for the Attorney General, and for the first time you're not appearing as amicus but as a respondent, could you say something about Regulation 87.3 and the question I posed to Mr. Noroji? It would be helpful for us if we could hear you on that question. I believe those are my... Mr. Mahat, I may have missed this, but I still want to clear my... This is a question I posed to Mr. Murgora as well. So the format initially is JPEG. At what point exactly does it convert to PDF? Forget the CSV story. I guess Mr. Mulgore dropped that. But I just want to understand for myself. At what point you've taken the image, you've asked all the questions, very good questions you've asked, the system has asked you the question. At what point does it convert to PDF? I thank you all very much. Thank you, Judge President.
Thank you, Judge President. My questions will go to Professor Muigai. As we've been asked by a number of parties that they've asked us to settle the law around Article 138.3 and 10. In your submissions, you suggested that the term commission can be used in multiple senses. How do we know which sense will be applied when? As a former Attorney General, perhaps you can point out to us whether it is in regulations, it is in the law, but how do we know which sense is applied when? My second question goes to the history of independent commissions, and Professor Muigai, you sat on the CKRC together with my colleague, Justice Lenaula, and you do know that the drafters of the Constitution introduced independent commissions and independent offices to deal with issues of authoritarianism, accountability, transparency, and to do away with the issue of one person having power. But from the narrative that we're hearing here in the court, there appears to be an all-powerful chair who, so what is the check for this all-powerful chair if the commissioners have nothing to do with his role? What would happen if the chair was to announce the wrong results completely? Or if he was mentally incapacitated or sick, or worst case scenario, dead? Who then would announce the results? What is the role of the other commissioners? I think this is bothering me, especially because it seems to me that your client and the IEBC suggest that the chairperson works with the CEO, and I feel a bit concerned. The CEO is not vetted by Parliament. He is appointed, but he seems to wield immense powers over and above the other commissioners. I cannot imagine that that could have been the intention of the drafters of the Constitution. So what role do these commissioners actually do? Because it hasn't come clearly. Or, for example, if one commissioner says he's in charge of ICT, what does that mean? Does it mean he's in charge of ICT until the presidential election, then he's not? What does it mean? What is the role of these commissioners? And I'm asking this question more towards trying to understand the leadership and the management in the commission as opposed to the management of the presidential election. Because I think they're two separate issues, and I'm trying to figure out whether this is a Chebukati problem, is it a leadership problem, is it a commissioner's problem? What's this problem we're seeing? I'm trying to understand that, and I'd like to hear that from you. Thank you. One more question, sorry. When the results come for other elections, so you have returning officers for senator, for governor, for MCA, and they're all announced or declared locally at the polling station, constituency, county, how is that information transmitted to the public? And when that information is transmitted to the public through a gazette, person only, who is involved in the declaration or the transmission of declaration publicly of those results? Thank you.
Thank you, Chief Justice. My first question, I think, could be addressed by Mr. Karori. In the morning, you do verification, tallying, and declaration of the result of the presidential election. That really, if you look at the law, in your interpretation of the Article 138 and the jurisprudence that you say emanates from this court, you seem to be arguing that that is strictly within the purview of the chair's mandate, and that really these other commissioners, let's say the remaining, the 6 commissioners, really ought not to be around that, because that's a role preserved for the chair. But then you said, according to the statute that establishes this commission, the enabling statute, the roles and functions of the commission, Quack Commission, are stated. One of them is oversight. What is oversight? If, in fact, the commissioners, I would have thought that one of the most important oversight roles in the commissioner's life would be when they are overseeing the verification and tallying of the presidential election result at the center before the same is then declared on behalf and for, and but for the people of Kenya by the chair. So what is oversight? I ask this because we were informed yesterday, and I think you were here, that instead of perhaps playing this role, some of them were allocated welfare scenarios, protocol, and media. But what is oversight? What would they be oversighting over? That's the question. In other words, at what point in this corporate entity scenario does the chair then disengage from the other commissioners? Be they 2 or be they 5 or 6? When do you say this is chair qua chair and this is chair as part of the commission? Because we need to understand that. We've been asked to provide clarity. Then let's go to Mahat. Mahat, there is this story about this Venezuelan. And one of the issues is whether the technology system employed or deployed was penetrated. And you did tell us, again, quite robustly, that there was no such penetration or infiltration or intrusion, whichever. But you did also concede that this Venezuelan, whatever his name is, had access to the server. But your answer was that the contract between the IEBC and Smartmatic was to supply and maintenance. So if I understood you correctly, this Venezuelan was accessing the server as part of the maintenance. So what is this maintenance? What does it entail? What was he doing there? Say he was released and locked out just before the election. So what was he maintaining in that system? Maybe you just want to tell us what maintenance entails as part of that contract agreement. Then back to the question of percentages again, in terms of the turnout. I think I asked this question, I asked Mr. Orengo, but now that you may not have another, you may also want to address it. In the arguments that have been presented before us, Mr. Chebukati, the chair, first mentioned a 65.4% turnout. And then he did indicate that that was bound to change as results kept streaming in, especially if you took into consideration the number of those who had voted manually and the numbers that had yet to come in from the elders. Now, it is the petitioner's argument that if there was to be any change at all, then that percentage would have to increase rather than decrease. So I don't know. And how relevant, again, is this turnout to the determination of whether a candidate gathered 50% plus one vote? And then, you see, we have been asked by Mr. Ngatia, who do you believe among these two protagonists? Who do you believe? This question has been put to us, and believe you me, we will have to deal with it. Who do we believe? Now, the question of the National Security Advisory Council. This, I think, Mr. Oraro, this could be of interest to you. On the one hand, you are telling us that this personnel visited the premises at the Bomas to express their concern, because, of course, being an advisory council, they must have arrived at a conclusion that unless the results were released, then there was bound to be chaos. But on the other hand, the chair, in his affidavit, tells the court that the only reason the AG, or I mean not the AG, but the individuals, distinguished people for whom we have a lot of respect, paid that visit, was to tell the chair to somehow re-engineer the results in favor of one of the candidates. Now, this is not a question to you, but a question to Mr. Chebukati's counsel. Professor, you may want to, or even Mr. Karori, are we to assume that by the time Mr. Kinyo placed this call, if the intention was to influence the declaration of the results, to change it, to re-engineer it, are we to assume that by the time that call was placed and by the time this gentleman paid this visit, they already knew the results? Because there's no way they would have been on that mission if they had not known the results. So are we to assume that if this be their mission, are we to assume that they already knew the results? Okay. Then finally, Mr. Kilokumi, you know, you cited King Solomon. And this court treats Holy Scriptures very seriously. you came up with, you say there is victory. Because in King Solomon's story, the protagonists were distinguished mothers. But here, you called them two gentlemen. But I also remember that one of the mothers who turned out, or the mother claimants, who according to Solomonic wisdom could not have been the mother, is the one who was saying, cut the baby. But the other one, I remember, said, no, let her take the baby. Because what she was interested in is to preserve the baby. Would you be willing to advise? I rest my case.
Okay. Thank you, Honorable CJ and President of the Court. I just have one inquiry, one question for the respondents, and it may go to, actually it may be answered by either the counsel, Senior Counsel Gidu Migai and his team for the first and second respondents, or it could also be taken up at the same time by counsel for the ninth respondent. That is the team of the team of Senior Counsel Fred Ngatia. It's my understanding that one of the submissions and cases in response by the first and second respondents, on the one hand, and the ninth respondent, that is the President-elect, are placing the blame on the events of the ninth at the Tarling Center, Bomas of Kenya. That the two groups of parties are placing the blame on the first and second petitioners' agents and sympathizers and supporters during the tallying and verification. Of course, we have images. Some of us, many of us were not there. At least the bench was not there. But we have images which we saw on TV. We cannot say anything about what exactly happened. But we just know there was commotion, and people are throwing chairs and even perhaps attempts to harm each other. But we cannot say anything about it ourselves as a bench. Neither were those matters before us in these proceedings. No evidence or allegations and affidavits. We have seen the affidavits, seen the submissions, but no actually determination or delving into any evidence. So, and yet there is a request, a suggestion that we should attribute and apportion blame among the we should place the blame on some parties, particularly the petitioners, because of their agents, supporters, and therefore actually you expect, particularly I can see the submissions of the ninth respondents, and even I saw the affidavit of Professor Goulier, where he actually says he expects action to be taken to investigate those criminal election offences. So I just wanted to inquire that would you expect, having had such elaborate submissions and affidavits, would you still expect us to make a determination, apportion blame, attribute blame, yet really the matter is not before us? Neither are we witnesses, neither were we at the Bomas, neither were these matters had on merit before us. That's the question I would like you to think about and reflect. And when you come back, you will tell us whether you expect any release from us on that aspect. Thank you.
Thank you, Judge President. My clarifications will be sought from the team led by Professor Gidu Muigai, Senior Counsel. The first clarification I seek is as follows. As regards the requirements of Article 140, and just remaining within Article 140, and even considering that the 4 new commissioners only arrived in, was it September last year? And whatever it is they've been doing on a day-to-day basis, please clarify in my mind, because it's a major issue here, what the constitutional role of the 6 commissioners is under Article 140. And once you tell us what it is, just position their role against that of the staff of the Secretariat and of the Chair. To the same team, and that is as per Article 138 3C, to the same team, of course, numbers are critical. They are, for me, they are. Because that is a mandate of 138 for A and B, the threshold, the 50% plus 1. And numbers are important for as long as they are not negated by any other process. And numbers would point to a good election, a good result, if they are not affected by anything else. And if Article 138 for A and B are not enough, deriving from them, this court in 2017 told us that although numbers were very, very important, other things could affect the numbers. Now, here is my concern. With the fact of the numbers being undisputed, they are important, kindly comment on whether or not, this question flows from the first one, the walking away of the 4 commissioners to go and hold, was it an IEBC meeting at Serena? Or was the IEBC meeting at Bomas? But please comment on the walking away of the 4 commissioners almost at the same time as the chair was about to declare the results. And in fact, I recall, because I was glued on TV myself, among their first words were that we have done an excellent job as concerns this election. But the results that the chairman is about to release are his results. So please comment for my benefit that working out and how was it timed? You've got to know, because these are your clients, that they would be walking out of Bomas to Serena to allow all media houses, in fact, except for the violence that occurred at Bomas, the split screens of media houses would have been showing each one of them addressing us, the Kenyan voter, at the same time. In fact, at one moment there, I thought the team at Serena would give us their numbers, and the team at Bomas was going to give us their own numbers. So my concern is, does their walking out mean anything under Article 140? If it does, what is it? If it doesn't, why not? Still on numbers, and answering all of us, yours and our issue number 4 and 5, we were told, and I need clarity on this one because it cuts across two main issues, that the voter turnout, was affected by the postponed election. Now, this is my concern. On the 9th, we were voting for 6 people, 6 officers. And we actually voted for 6 officers, including in the places where elections were postponed. And we were told that turnout was affected by the postponement. And since you are the central player in this thing, you could pass this to Mahat or anybody else in your team. Did the postponement affect only the vote of the president? And since we are in the habit of taking judicial notice, and since I am in a position to take judicial notice of the fact that elections have since happened in the postponed areas, have the subsequent elections returned a different result as to turnout? Because that happened, was it Monday? And we have yet to write a judgment. If they are affected, in what respect? Mr. Mahat, you told us that there is a holy place. You called it a sanctified place for the agents. And that it is the responsibility of parties to have agents. Your sister, while submitting, Ngania, told us that in 2017, we also emphasized the position of the agent. This is my question flowing from that, and it goes to the process of the election. What if there were no agents? The Article 81, I think 81E, places the burden of ensuring that we have a fair, free, transparent, accountable, and all those things, election, where, for whatever reason, agents are not present at an election. Is it not the role of the IEBC to ensure that Article 81E is upheld? And in the event, I know you said in Tiati some constituency there, in fact, there were no agents from anyone. The process, and where there are no agents, the process. Finally, we have seen the Somebody named the 4 commissioners as respondents. One of these petitions, or some of them, named them as respondents. I think someone had even named them as interested parties or something like that during interlocutories. But by whatever name called, they remain commissioners. I have also seen, we have seen, affidavits that they have sworn, which tend to show that they take certain positions. Now, what is the position to be taken by a commissioner? Is it a position of the party, any party, or is it the neutral position of the IEBC? And when they take, as I think they have done in this case, the position of any side, what is the court to do? Did I say finally? Then I'll say the second finally. That Kenywa's call, Mr. Joseph Kenywa's call, and whatever else that happened, the night meetings, the security issues, and so on and so forth. The name of this commission starts with the letter I, which says, I stands for the Independent Electoral and Boundaries Commission. And in the body of 88 going down is that, and even in their act, they shall not be directed in the manner in which they do their work. But I want you to clarify in my mind, because it's now an issue here, when it comes to writing the judgment, what do you want me to write? There are commissioners, and we talked about the dysfunctionality. It came from you, it didn't come from this side of the bench. Of the commission, I'm glad today I have had an attempt at answering my question yesterday as to when it became dysfunctional, but I'm still waiting for answers from the person to whom the question was directed, which is the petitioners. But tell me what the IEBC was supposed to do. On the one hand, they are being told, hurry up and announce. On the other hand, the court, as represented by the Honorable Mr. Justice Isaac Lenaola, is saying, but there is still time. There is yet another day before you can announce. What is the IEBC to do? Thank you. Thank you very much. Thank you, President.
Thank you, colleagues, for those questions. I think they were quite comprehensive. The team led by Professor Geth Muigai, you can see what we want to understand is this disconnect arising from IEBC. Because when we look at Article 88, the role of IEBC is to supervise and conduct elections. I do not want to repeat this question. Why the chairman deemed it fit to allocate commissioners, I think what has been described as domestic chores, leaving the core business of IEBC to the CEO to supervise. We've been told that they did a good job in the polling stations. Polling went on well, counting tallying and transmission until the National Tallying Center, where they are all there, but they are not doing the core business of, according to the Constitution, they are being given other duties. This is bringing a lot of questions in our minds. Then when we look at Article 138, 3C, we see they have a law, at least to look at the tallying results and ask questions whether the president-elect met the constitutional threshold before the chairman can go and announce the results, because we all understand nobody can tinker with the forms 34As and B the way they have come. And you have heard IEBC being likened to the Supreme Court, much to the chagrin of the judges here, because the question which was being asked, I think, by Mr. Otieno is that if 7 people are sitting on a judgment or a decision and there is a dissenting voice, why didn't the chairman tell Kenyans exactly what happened? That we conducted this election, we came to the National Tallying Center, we have these results, but some of the colleagues have a dissenting voice. They will tell Kenyans why they are dissenting. Another thing that worries us, and I think your team should answer, is why the live streaming of the results stopped. Because if Kenyans were able to follow the streaming from the beginning to the end, which was being done in the spirit of accountability and stability and transparency, then the rhyme which we were being told of the pige ponki would not arise, because there would have been no confusion. We know this is how things are happening, and therefore maybe the losing candidate who is being called to go to the National Tallying Center can decide not to go, because they know already the results they are on the screen. So I would also like a clarification. The question has been asked, and it was demonstrated very ably by Mr. Mahat. I would really like to follow his presentation, because he did it with passion. Mr. Kirago Kemani also did it, but I think I want you, Mr. Mahat, to, just demonstrate how the forms 34A that were attached to the affidavits of the respondents were photoshopped. I think I liked your language of photoshopping, and I could follow it, but I want to understand exactly how they were photoshopped. I think that is what I would like to ask. Thank you. Oh, one more.
Thank you, CJ. Sorry, I don't know whether it has been, but time without number, the issue of the 27 constituencies whose results, it is said, had not been included in the final tally before the announcement was made, keeps coming up. We have been told that in fact, these 27 constituency results had been verified and tallied. But because of the commotion, somehow they would not be part of the announcement. But why did the chair, just before, when calm was restored, why would he not have included them? Because they had already been verified and tallied. Or did not include in the final, so that they shouldn't be here bothering us? Why was it, where was the hurry this time? And already the results had been tallied and verified. Thank you, CJ.
Sorry, I just forgot a quick question, Professor Muigai, regarding my questions on Article 138. What is the implication of what you are suggesting on the chairpersons of other commissions? And I say chairperson, I noticed today everyone's talking about chairman. The correct term is chairperson.
Senior Counsel, I think myself that, and if I'm wrong, please correct me, that the most important day for a commissioner of the IEBC has got to be that time that they are doing the presidential election, and I think there is a reason why their term is 6 years, because our elections are every 5 years. So that, I think it's likely that in the 6 years, or whatever time one gets in, a commissioner would have to conduct an election, a general election. Let's not just say presidential, but a general election. Therefore, what is the role of the commissioner, the 7 commissioners? Back to my question number 1, and strictly under Article 140 for me, and 138, 3C. Thank you.
My lady, my lords, we thank you for those very incisive questions. My team has requested me to very humbly request you to give us time, because you place much weight on those issues. We would equally want to come back, not with off-the-cuff remarks, but with well-thought-out responses that can help you appreciate the issues you've raised. And I think that would put us in parity with our colleagues, because you raised questions with them yesterday. They've had 24 hours. I think they are still mulling over them. In their case, I think there were more difficult questions. If you would very kindly allow us to respond tomorrow morning, we assure you we will not take more than the time you will allocate us. And this is particularly for Mr. Mahat, our numbers expert, because he would like again to have something to demonstrate to the court on the screen. Thank you.
Yes, we are consulting because we did not want to give you a second bite of the cherry. You know you have no right to reply as respondents. But we have asked these questions on the tailhead. The hour is also late, but you know we are operating under very, very strict timelines because of the extraordinary circumstances of this matter. We have agreed to allow you to respond in the morning, considering that if you put your minds together, you'll be faster in the response than if we do it now. So we will give you 15 minutes tomorrow morning to respond, first thing tomorrow morning, to respond to those questions.
My lady, we don't want to sound ungrateful. We welcome the change you have made and thank the court, but we would request 30 minutes. And we will try our best, although you've asked these questions of many of us, we will try to have at the very most 2 people speak to it. 1 person to the law and 1 person to the numbers. Thank you very much.
Thank you very much. Yes. Thank you very much. I think that brings us to the end of today's proceedings. We will share in the course of this evening the report from the discovery or the scrutiny that went on. And then the order of business tomorrow, we will start with the team of Professor Githu Muigai responding to those questions. And then we will hear the rebuttal by the petitioners. And thereafter, we will give the parties who are participating in the scrutiny. That is the first petitioner, I think youth advocacy, CARIF, then IEBC, and the first respondent to comment on the report on scrutiny. We'll give each 15 minutes, because we are trying to see how we can bring these proceedings to an end, at least by midday tomorrow, so that for us we can retreat to our chambers to work, to do the biggest job that has fallen on our hands, to come up with a judgment by Monday. So we will continue to ask you to bear with us and be very kind to us. Thank you very much. Have a very nice evening.
Cascade Institute of Hospitality